Hello everyone, and I thank you for tuning into this video. I rarely do case reviews, but I am doing this because I think more and more people should actually know what this actually means for us, especially if you are a business owner or a citizen or even a person who resides in the United States. Well, as we know, we have a multi-tiered governmental branch system. And in that system, it includes the president's ability to appoint heads to run what we call administrative agencies. You likely know them as the Internal Revenue Service, Department of Transportation, things of that nature, right? So these agencies actually hold a lot of impact in our day-to-day actions. And so they are governed, and meaning they establish the rules that we have to follow under a policy called rulemaking, right? And rulemaking is the agency's ability to create rules that we will have to follow, but it doesn't mean that just because they created a rule, it's automatic. The administrative the APA Act outlines how they are able to do the rulemaking process. So this means that if they do want to create a rule, they have to publish the proposed rule, and we as citizens and people who may be impacted will can offer what they call comments on how we feel about the proposed rule. Well, if after the proposed rule making procedure happens and we comment and we go through the whole thing, then the agency can then do its power or inherent power of rule making. Okay, so once that happens, a rule comes out, boom, bam, all right, cool. So now it's in action and it is now impacting certain groups or individuals, and the law says that if it's impacting you in the way, you can challenge it on various grounds, private right of action, all this other stuff. But one of the key ways you challenge it is by saying the rule was not created in a fair way, or whatever your ground. Well, as we know, these administrative agencies have a bulk of research and knowledge as to why they do that. So when you enter into a new arena, such as a court procedure of something of that nature, the court doesn't have that same breadth of knowledge as to why the administration, this agency, it created the rule it did and the steps it took and all those things. So when the court needs to get understanding about a rule, the Chevron Doctrine was based on the policy and understanding, and it was written by the late Justice Scalia, that said a court can defer to the administrative agency to offer an explanation of the rule and how it came to be impacted, the whole 9 yards. So that means if you challenge an administrative agency and the law needs to get an understanding of what it meant and interpret that rule, the law says that the court would get that interpretation from the agency that created the rule. So that means inherently you challenge the administrative agency's rule. You say it's impacting you. The court says, I don't really understand. I need an interpretation of what this rule really means. The court goes to the person you're suing to tell the court what it means. And the court can then use the deference, meaning the establishment and the explanation offered by the administrative agency, as the foundation for how it will interpret the rule. This has come to be known as the Chevron Doctrine and has impacted several people. It's sort of like saying, do as I say, not as I do. You know, as kids, we were told that our parents, whatever they said, that's what we had to do. Sometimes it made sense, but oftentimes it did not. And that is ultimately what the Chevron Doctrine impacted so many people. So with the overturning of this latest opinion with the Loper Bright Enterprises, with this is huge. The Chevron Doctrine has been in place since 1984. and it's ultimately given administrative agencies from a federal level all the way down to a state level the ability to pretty much offer explanations that they draft to have courts interpret their own rules that are getting challenged. So this is huge. This is actually something that can really steer the course of administrative agency law as we know it today. As a law student in the 2011, I took my Administrative Procedures Act class, and it blew my mind at the authority that a lot of these administrative agencies have. And yes, we can comment and be a part of the rulemaking process, but in the event that it gets challenged, this is where the courts would go back to the administrative agency and ask them to offer an interpretation, and it could be followed. And that is what we called the Chevron Doctrine, where administrative agencies could offer deference, meaning opinion, what it meant, and the court could lean on that deference provided by the administrative agency. So this is a big, big day in AP law. I would like to give a shout out to my professor, Rod Sullivan, who taught me what I know about the APA. And this is something that I've been following from oral arguments all the way down to today. So I hope this explanation is helpful. I hope you understand the impact of this 6-3 decision. Thank you for watching.